Good morning. Can we make our ways to the tables? Pete. Can you make our way to the tables? Thank you. Thank you. Well, good morning. Welcome to the June 7th North County Estate Planning Council San Diego meeting. Wendy, they don't listen to me. Sorry, this my ear. Please take your seats. We're going to get started. Well, good morning. Welcome to the June 7th meeting of the North County Estate Planning Council. Thrilled to have you all here. This is the next of our in-person meetings since October. And of course, it's so great to see everybody here in person. And of course, our web Zoom attendees, thank you for coming. We know it fits into members that have children and others who aren't so early bird oriented as I am. We're thrilled today to have Wendy Goffe from Stoel Rives in Seattle, and we'll give her more of an introduction in a second, but her area of passion amongst many is planning for beneficiaries with addiction and mental health issues. Just before we get to the intro, just some announcements to make. We are planning a social event probably in the next month or so. So we'll be in touch and letting you know where that when that's going to be, most likely here or Viewpoint Brewing or in the Del Mar area. Pete, do you want to say a few words about our trifectas?
Yes, but first I'd like to say thank you. There's much bigger turnout than last couple of months, so I'm glad to see more and more of us are coming back out. Welcome back, familiar faces. Welcome new faces. There's a lot of new faces here. And what we do here at the North County Estate Planning Council is that we put our name in a business card in a fishbowl here. And what I'll do is I'll try to pair you up with somebody that's going to complement your industry. So there'll be 3 of you getting together, whether it's for coffee, breakfast, lunch, maybe even a hike, or happy hour even. And the idea is to just get to know each other more on a personal basis. And when that happens, we find that business comes about that as well. So thank you for everybody for participating. The bowl's a little bit light. So what I'm going to do is I'm going to pass that around starting here and going back all the way over here. So if you haven't put your business card in and you want to participate in the trifecta, please do so and call me if you have any questions. Thank you.
Pete is our master networker as well as a reverse mortgage expert. So certainly take advantage of the trifectas. The interesting side of the trifectas is you find out what each of you are working on and give you a better idea of how you can work together. So thank you, Pete, for managing that process. Just an update for our July 5th meeting. We've got Pete Tentler of Independence Reverse Mortgage Solutions and Paul Hines of Aspiriant. We're going to talk about reverse mortgages and planning for cash flow needs as we approach the retirement age for some of our clients. Upcoming meetings, August 2nd, Phil Sullivan and Jeremy Crickard of Sullivan, McGibbons and Crickard and Associates, both Act Tech fellows, and they're going to be presenting on key tax planning techniques that they have been employing with their clients for taxable estates, for those in excess of the 11 million for each person, but really from 30 to $50 million in net worth. September, we're going to have a presentation on philanthropic planning, and more details of that will be coming. In October, we've got Stacy Aldred of First Republic Bank, who's a national thought leader on family governance, preparing the family for the wealth, and family business succession planning. She's a national expert. So look forward to seeing you all for the October 4th meeting. Certainly visit our website. For those of you who don't go there regularly, you do have the ability for the members to update your profile. We've kind of left it to you to deal with that. So update your profile as needed. And if there's any questions, we've got David Jacobs that you can get in touch with. Our board members, David Jacobs, out with COVID. Phil Sullivan is visiting via webinar. Pete Tentler and Barry Levine is also visiting via Zoom. Without any further ado, I want to introduce you to Wendy Goffe, a good friend from Seattle, nationally noted speaker, a member of Act Tech, a fellow in Act Tech. As you've seen in her bio that's attached to the meeting announcements, prolific writer, prolific speaker, and of course, hugely involved in the community in Seattle. She's got a passion for this area of her topic today with that probably impacts every one of us, whether it's our own families, our clients, or other people that we know. So please join me in welcoming Wendy Goffe.
Thank you for having me, and hello to the people in cyberspace. Thank you for getting up. And I have new glasses, so if I look like I'm trying to focus, it's because I'm trying to focus. Yeah, you get to a certain age, right? So when people are thinking about their estate plan, I would guess that most people walk into your office and say, I just want to treat my kids equally. That seems to be the default, and nobody is equal in our world. And this is true even when they're aware that they have a child who's struggling. Often they don't want to rock the boat. They just, maybe they're just worn out dealing with the kid who's got a problem. So let's just deal with it equally. I'll be gone, right? Oftentimes, the client won't disclose that there's a problem. And you may be, as the estate planner, the first person to recognize that there is a problem. Often I find I'm, like the family doctor, and I think you guys probably are too, because the client sees you on a regular basis and you may be their only trusted advisor. So when they have a problem, they call you. So it's often that as the estate planner, I hear the deep, dark secrets about the issues between the kids. But at the same time, if we don't ask the right questions, we're not going to get the right answers from some clients. And I'm sure you have the client who just feels like they need to tell you absolutely everything. And you're like, I could have gotten the work done in the time that you just told me that story. Let's just move on. But we have to ask the right questions. So recently, a representative of NAMI, the National Association on Mental Illness, and if you don't know about that organization, look it up. They have some great programs and family family therapy programs and individual programs and call-in numbers for crises. But she made a couple of interesting points about COVID. And one was the pandemic's exacerbating effect on already existing mental illness and addiction issues. But just as important, she said, those people who've never experienced any issues in their life are experiencing issues. I think every one of us coming out of COVID could use some therapy and, a Prozac. Or maybe I'm just projecting. So the silver lining of that is that it's brought the issue to the forefront. It's pretty hard to deny that there are mental health and addiction issues out there because they have been exacerbated. I just want to make a comment about terminology. Addiction and mental illness are often related. People may have a mental illness and they self-medicate. And by self-medicating, they become addicted. It can go either way. Addiction can lead to mental illness can lead to addiction, but they're usually tied. And I'm going to use the terms interchangeably or as a catch-all. So as estate planners, we need to be proactive and intentionally initiate the conversation with our clients to identify those mental health and addiction issues. And let's talk about what addiction means, because historically it's been excessive and interfering patterns of substance use, and that's pretty narrow. According to the National Survey on Drug Use and Health, this was before COVID, almost 20 million Americans aged 12 or over were living with a substance use disorder. And that's before COVID. Almost 74% of individuals living with a substance use disorder used alcohol, and 38% used illegal drugs. So if you count that, that adds up to more than 100. So there are people who are using both. They usually have a substance of choice, but if that's not available, they'll take something else. That same year, 1 out of every 8 individuals with a substance use disorder also struggled with drug and alcohol abuse. With a mental health disorder, struggled with drug and alcohol abuse. So those numbers don't even count addictive behavior. That's just substance abuse. And if we bring addictive behavior in, that raises the numbers exponentially. And we'll talk a little bit about addictive behavior. So for every taxable estate that you have walk through your office, you've got dozens of addiction issues. It's just inevitable because there aren't that many taxable estates, but there are a lot of addiction issues. So we need to normalize the conversation. We've all learned somehow to talk about death and how do you want your remains to be disposed of, and are you a gender now that you didn't used to be? Do you have genetic material in the freezer? It shouldn't be that hard. Okay, maybe you don't all ask those questions. I do. It's in my questionnaire. So if you have those questions in your questionnaire, it shouldn't be that hard to talk about addiction. We need to learn to identify the signs of addiction, not just in our clients' children, but in our clients, their fiduciaries, and all their advisors. I mean, we need to be on the lookout for these things because it's everywhere. And then you need to understand the resources available to you. In your materials, I've given you a list of resources. Those were hot links. So I don't know if Bill's going to email those materials to you, but if he does, then you can just click on them and they should go right through to the website. And that's just a start. But each of those hot links then has many more resources. And we need to learn to take the steps from a legal and a planning perspective to protect family members and protect their resources and the inheritances and protect the rest of the family from further damage. And family is broadly defined as family by choice or family of origin. And it's important that we understand the correlation between wealth and addiction, because there is one, and it looks a little different when there's money than when there isn't money. Addicts and alcoholics don't often change without massive consequences. And I'm sure you've all heard the term hitting bottom. The thing is, when there's money, the bottom can be a lot lower, and it can take a lot longer to get there because you've got ways to sort of scaffold yourself up with money. So let's talk about that. The consequences can be interpersonal. It can be health, financial, loss of faith, loss of job, but a lot of our clients don't work, loss of wealth, and maybe the end of a marriage. Multiple core areas of functioning usually have to become affected before changes are made by the affected person. And when a person suffers very few financial consequences, if they don't lose their job or they still have enough money, it just takes a lot longer to recognize the problem, either for them or for others. And so this is why the wealthy might be able to cover it up longer. And I have to tell you that as long as I've been working in this area, I too am surprised by, the death of a client who died from alcoholism, and I never knew that it was an issue. And they talked about, this has happened several times, they talk about other people in their family who have problems, and I never knew that they had one. They're also able to evade the consequences. And you may not know it, because this is something I've only learned in the last couple of years, and I've been practicing for 30 years. There are law firms, mostly on the East Coast, that serve as fixers. They make problems go away. Whatever that problem is, they can, with enough money, they can bury it. They can engage search engine optimization companies that make that news story show up not on the first page, but on the 175,000th page. And they do amazing things. So our clients have the money to engage those folks. It's pretty amazing what they do. And people are enabled. A lot of us just, they don't want to deal with it. So they ignore it. I have clients who have a security detail who follow them 24 hours a day. They live in a house a block away, and somebody's always on rotation. And I know that those clients have addiction issues, and it's inevitable that the security detail is fully aware of everything that's going on, more than I am, and they're duty honor bound to say nothing. So they live with that information. Sometimes there's a spouse who's in a not particularly happy relationship, but there's a lot of money available to them, so they let the addiction issue go. They don't want to rock the boat, or they're scared to rock the boat. And that's something else we should be aware of. And that's a whole other topic of violence. So in the statistics, the definition of addiction is changing as we recognize other behaviors that are equally significant and impact life as much as substance abuse on a person's on the level of well-being. More recently, addiction has been proposed to have several defining components. And again, it's important for us to understand this. Diminished self-control. So it may not matter how much someone is using, but if you recognize these components, it's a problem. Continued engagement in behavior despite adverse consequences, diminished self-control over engagement in that behavior, compulsive engagement in that behavior, and an uncontrollable urge or craving state prior to engaging behavior. Who's thinking about those definitions and their use of social media right now, doom scrolling? I think there was a time during COVID where I just couldn't stop reading Instagram or Facebook. But I think we're okay, as long as you're not drinking while you're doing that at breakfast. Coffee's okay. So the American Society of Addiction Medicine defines addiction as a treatable chronic medical disease involving complex interactions among brain circuits, genetics, the environment, and an individual's life experiences. So it's a combination of all of those factors. People with addiction use substances or engage in behaviors that become compulsive and often continue despite harmful consequences. And it may, as I've said, take several forms: legal substances, illegal substances. Now with marijuana, we have to decide, when does it become a problem because it's legal? And behaviors: gambling, sex, shopping, eating. Those are also addictive behaviors that can lead to the same bad consequences and bad endings as alcohol and drugs. And then there are other kinds of substances that you may not even be aware of. You wouldn't think about it. You wouldn't look for it, but people sniff glue, they inhale nitrous oxide. I found out that's called whippets. And I heard the term whippets, and I thought it was dogs. So, you have to learn the lingo too. So it's somewhat controversial to talk about behavior as addictive. Gambling right now, gambling disorder is the only behavior that's made it into the Statistical Manual on Medical Disorders, the DSM, and we're now on the DSM-5. I think in the next edition, the DSM-6, there will be other behaviors, but right now it's considered that there's insufficient data. Although I think that all of you from your practices can see that internet porn and shopping and eating are just as destructive. And they're usually not, people don't single those things out as just like drugs. There's the drug of choice, but if one thing isn't available, people will turn to another. So there's a non-scientific definition, and that includes substances, alcohol, drugs, prescription medications, and other harmful substances, as well as addictive behavior, which affects the beneficiary's emotional, physical, or financial health and well-being. So it's more based on the beneficiary and or the individual and what it does to them. So I think if you look at it that way, the definition becomes much broader. When you're drafting for a client, I would suggest that you use some combination of the scientific definition and the definition that deals with how it affects the beneficiary. And that requires a conversation with the client about if you're drafting for grandpa or grandma who wants to leave money to an addicted beneficiary, or even just beneficiaries, and it's inevitable that among that class of beneficiaries, somebody is going to end up with an addiction. What does it mean to them? Is it just dissipation of money? Or is it harm to themselves, or is it both? And I think it really requires us to educate clients about addiction, because some people don't know how broad it can be, and they're only thinking about one thing, the dissipation of money or the effect on health. They may not be thinking about the combination. So let's talk about, again, I want to talk about some generic signs. And remember that the wealthy can hide these things, so it's a little harder to notice. But a change in self-care, that can be a sign. A lack of purpose. And these are things that you can think about when drafting for the beneficiary, and ways that an interested trustee can help bolster this beneficiary. Lack of self-care, lack of purpose, increased depression, fluctuating moods, lack of patience, irritability. Here's something that a lot of us might notice: irritability around not getting money fast enough, where that didn't used to be an issue, whether it's from the trustee or from the financial advisor. They've asked you to liquidate something and get them some cash, and that cash just isn't coming. It's taking 48 hours, not 24. Changes in communication. Here's another one that's really important: only being willing to meet later in the day, usually because they're not doing well earlier in the day, they're sleeping in. Okay. Frequent ER visits, and that might not be something we know about, but if it is something they share with you, frequent ER visits for sort of ambiguous things like, well, they fell, or they just had a stomach bug. That, we all have those things, but a lot of those things clustered together, usually a sign. Missed appointment, and then flimsy excuses for missing the appointment. And the other thing is calls at all hours that may be urgent. Except for my one client, David, where everything's been urgent for 30 years. We'll give him a pass. He called when my husband was in the ICU once, and I said, my husband's in the ICU, David, I will call you back. And he called 4 hours later and said, I assume your husband's still in the ICU, or you would have called me back. I'm just checking. But anyway, that's David. I love him. So I'm sure we all have that client. So again, let's normalize this discussion, make it just like taxes, just like burial and cremation. So how do we draft for our client without this getting crazy complicated and crazy technical very quickly? Because based on what I've said, it can be. And it's not uncommon for our client to have very different issues about what's going on than we do. And just think about it as far as parenting. I mean, for everybody who's a furry child parent or a child on 2 feet parent, in couples, parents usually parent differently. There's the permissive parent and the authoritative parent, the uninvolved parent, and the authoritarian parent. And I told a few people some story about my daughter. My husband's been having conversations with her, and he's been texting me, okay, this is what she said. What do I say? And I text back, this is what you say. And then he texts back, she said, I sound just like you. So, parents parent differently, and when there's an addiction issue or a mental health issue, it's really important that the parents align and that they don't let the kid split them and work them. So if you recognize that clients parent differently, you have to kind of read between the lines, because they're not going to present the same story from the same point of view. And often the client is coming to you and they are that frog that's been in the boiling water and they're just tired. So they may have come to you and said, okay, we've got this addiction issue, but they are just so tired. They just want you to draft something. Don't you have a form? And as we all know, we have forms, but that's just the starting point. There are already likely existing conflicts in the family. So not only do you have to deal with addiction, but you have to deal with the fact that the other kids are really angry that maybe the addicted beneficiary has already dissipated a lot of the family money, and there may be plenty of money left even, but there's usually anger. The kid who's the worst behaving gets the most attention, and the one who lawyership, they're fine. So they don't get any attention. And in fact, the addicted beneficiary might have ended up in the ER and mom and dad went to see the kid in the ER or the ICU and not to the Harvard graduation. And so, these things just create generation and generation of anger over one relatively small event. Sometimes the parent just says, I will see that kid at their funeral. I'm done. And other times they throw money at the problem to keep the peace. And they'll tell you, just, draft so the trustee can do what I've been doing. I don't want to do it anymore, but something needs to be done. Clearly, that's not going to be the right solution. And we're not doing our best if that's what we draft into the document. So we cannot figure this out on our own. We are just one member of a team of professionals. And to the extent the client has the resources, the bigger the team should be. And you need this team to both advise you, to inform you on how to draft for this beneficiary, but then how to carry out the terms of the trust going forward for the rest of the beneficiary's life. And I'm going to talk about the members of the team in a minute, but I just want to remind us all about our ethical duties to a client and a beneficiary. And under the rules of professional conduct, the model rules, we have rule 1.14. And I know in California, you have not adopted rule 1.14. For the life of me, I can't figure out why, but you do have California formal opinion number 2021-2007. That's not in the materials, but 2021-2007, and it adopts the terms of 1.14. So you have it in another form. So under 1.14, the lawyer-client relationship, when a client's capacity to make adequately considered decisions in connection with representation is diminished for any number of reasons, the lawyer shall, as far as reasonably possible, maintain a normal client relationship. So this only applies to the lawyers, but I think in all of our allied professions, we have a duty to serve our client and maintain confidentiality and meet them where they're at. But when, and this is the model rules, when the lawyer reasonably believes that the client has diminished capacity and they're at risk of physical, financial, or other harm, the lawyer may take reasonably necessary protective action. This is where you differ in California. In California, you have to have obtained informed consent from the client. So clearly that would have been before, in the before time, when they were not at risk of harming themselves. So presumably maybe during the intake procedure, you would have obtained consent to disclose that there's a problem. Clearly, a client with a problem is not going to give you consent. But so a few comments about Rule 1.14. Does the addictive behavior make the client's affect the client's capacity in your professional relationship? It may not. They may drink, they might sleep in, and they'll see you at 3 p.m. and they're fine. So in that case, you don't really have a reason to disclose that there's a problem. And are there other behaviors that are a problem for the family, but not for them? It's not up to you to disclose the issue if it's a problem for the family, but not for them. And I'm sure you've all seen the client who's creating havoc for everyone else, and they just kind of walk through like get smart. And when so I'll leave it at that, just because in California, you don't have the obligation or the opportunity to disclose. You can read about the model rules in the materials. So let's talk about trusts, because clearly trusts are a better idea than outright gifts. Outright gifts make little sense in this context. And it's important that the grantor or grantors are clear about the purpose. Clearly, maintenance, education, support, and health are not going to cut it. It would be a bad idea to have maintenance, education, support, and health, because you may be promoting a beneficiary's behavior by providing money, especially if you're providing money to them rather than on their behalf. Financial support has the possibility of promoting recovery if done in the right way, and a windfall is almost always a disaster. So you don't want that a third at 25, a third at 30, and the rest at 35. That's pretty old school these days. Even for the financially responsible beneficiary, I would propose that you just make that beneficiary their own trustee at that age if they're capable of serving as trustee, rather than just pushing the money out to them, because they could have the bad spouse waiting to, file for divorce. Ideally, the trust would provide for treatment and continuing support that promotes recovery without enabling further destructive behavior. And also, it's a good idea to provide in the trust that the trustee will help educate the beneficiary on managing money, because often beneficiaries with addictive behavioral problems or addiction or mental health issues are really bad at managing money. So as part of the recovery process, learning to manage money is really important. And until the beneficiary is able to manage their money, distributions on their behalf rather than directly to them are a really good idea. Something just to keep in mind, a special needs trust and an addiction trust don't really play well together. And that's because disability under the Social Security Act means serious medically determinable physical or mental impairment that renders the beneficiary unable to engage in any substantial gainful activity. An addict may be highly functioning. I was told a story last night about someone who was getting a PhD and died of a heroin overdose. And that's not that uncommon. I have lots of clients, actually, sadly, who have died of a heroin overdose the night before going into rehab. So they can be extremely highly functioning and addicted. So on the other hand, a special needs trust may cause the trustee not to be able to make distributions that would be otherwise a good idea for an addicted beneficiary. And I'll talk a little bit more about that. So you also have the chicken and the egg problem, that you don't know if someone's disability caused the addiction problem or the addiction caused the disability. And that's important for qualifying for a trust as a special needs trust, qualifying for public assistance. If there's a disability that exists, they might qualify, and then you also have this addiction issue on the side. But if the addiction results in the disability, then they're not going to qualify for public assistance. For special needs trusts. So the disability is the definition that the Social Security Act gives, which is the medically determinable physical or mental impairment. Did that answer the question? Okay. Yeah, there's more about it in the materials, but that's the whole world of special needs trust, which is, a presentation or two. So let's talk about clarity of purpose in the trust so that we know what is being covered. Will it cover basic expenses or only recovery related expenses? That's probably not going to be good enough to cover recovery related expenses. There's the beneficiary who's never going to be in recovery, and they're the ones who are going to need maybe the most money. Basic expenses, that's not going to cover recovery. We all have those clients who are insistent on, this is what I want and no more, no less. I just dealt with a trust for a trust company where the lawyer got conned into drafting a trust for 100 years where there were no distributions. I'm sorry, there are no distributions for the first 100 years of the trust. So, that's the kind of client I would send somewhere else, but eventually they end up with a lawyer who will draft it. So you need to be careful that you don't have that 100-year trust person in front of you. And if you do, you need to maybe help them understand that that's not going to work. So in the materials, I have a couple different definitions of purpose, and you can maybe massage those and use those to help counsel your client on what a good purpose would be, or give them some options so they can choose the purpose. But one of the things that needs to be drafted into the document is the authority to hire and rely on professional expertise. We cannot do this on our own. One of the first really great trustees that I worked with, so impressive. The client was 103 and he was her hairdresser. And Bill would remember in Seattle, the House of Edward, right there where 10th and Broadway come together, and all the senior states ladies, I don't know, of Seattle went there to get their hair turned blue. And this guy had access to all his other clients and could ask for referrals. And he assembled an amazing team of professionals. And then he went back to doing hair. He didn't try and do the job himself. So we cannot do that. We all have hairdressers. If we need some referrals, we can go to them. So in the materials, I've got provisions on allowing a trustee to engage professionals. But who are those professionals? There's the usual suspects, the lawyer, the trustee, the CPA. But then you will have doctors, you'll have psychiatrists, you'll have social workers. There could be a case manager. It makes me very happy when there's a case manager. That's a person who is the ringleader for all these professionals, so that the trustee doesn't have to do that, because the trustee isn't trained in that. A case manager is the person who manages all the other professionals and may hire and fire. You may have an intervention specialist. How many of you have ever participated or know what an intervention looks like? One person, two. Okay, so an intervention is where you have a trained specialist. And in Seattle, I work with someone who has both a law degree and has a PhD in psychology. And he brings together maybe a family, and the family will all write a letter to the person whose the intervention is the subject of. And they'll talk about how they've been hurt and how they love this person, but how they recognize this person has a problem, and how they've been hurt and how they're willing to help. And if the intervention goes well, that person gets in the car and goes off to the farm without horses, as we refer to it. I think in California, they may be nicer than they are in Washington. And in Washington, they're pretty basic places. But from what I've heard, they are nicer here. There may be a parenting coach as part of this. So to help the parents align in communicating with the child or grandchild, because not being in alignment is detrimental to everybody. There may be a security detail, and this is something that you might not think about, but if a kid is meth addicted or heroin addicted, and they've got this whole circle of friends who are hangers on and either supply them with drugs or use the drugs or buy the drugs. And that's their circle of friends, maybe their girlfriend. They go to rehab and they come back. And that whole circle of friends is going to glom onto them again and try and get them back into that addictive behavior. You may need a security detail to protect them from themselves. Now, this is a very wealthy client, but if it's possible, that's something you might want. So there are different models of addiction and recovery. And the one that I use the most is a 5-stage continuum. And it's a process of behavioral change of addictive behaviors over 5 stages. And I talked about it a little bit more in the materials. But individuals pass through these 5 stages when attempting to change behavior. And they don't necessarily go linearly. They can jump to the middle, jump back, jump forward. And this is where the team of professionals is really where you are and how you react. The first stage is pre-contemplation stage. That may be the stage where the beneficiary has no idea, or the client has no idea that they are unaware that they have a problem, but they may be becoming aware that there are problems in their life, but they're not necessarily making the connection. In fact, you usually see a lot of blame. Just everybody is hurting them, their boss, their kids, their spouse, and they drink to relieve the stress of what everyone else is doing to them. The next stage is where they actually recognize that there's a problem, but they may not be willing to do anything. They just recognize that there's a problem. And then the third stage is where they actually are willing to do something about it. So the second stage is contemplation. And I just to go back, there are a lot of excuses at that stage about why things are happening. Then there's the third stage where they jump into some sort of treatment. And often that's attending a 12-step program, but a 12-step program isn't for everyone. And just from a spiritual perspective, it doesn't work. Or they have problems that a 12-step program can't help. There's severe mental issues. They need to be in an immersive program. So then there are 30, 60, or 90-day programs. That's the farm without horses. A residential addiction treatment. There's also something called partial hospitalization, where people who don't go to a full-time treatment program might stay at home, sleep at home, but spend the whole day at a hospital or a treatment program. Go there starting with breakfast through dinner. But usually they're not working at this time, even if it's partial hospitalization. And during this stage 3, the goal is that the beneficiary gets through that stage 3, and the trust would then reward them for reaching that stage. And that's something that the client can decide what that means, that they get additional money, not just basic living expenses and their recovery funded, but that they would get additional money where they could use that for vacations. Now, if the client has a gambling addiction, that may not be the right thing. Maybe the money is distributed for their benefit. A vacation is paid for, but they don't just get money. And so recognize that for some addictions and for some people, money can be a trigger. Just some things about evaluating inpatient programs, because as the trusted advisor, clients may come to us and ask us, what do you think of these? The first thing is, what's the deductible? What is their insurance going to cover? Because that's all over the map. What's the copayment? Also, is it an in-network facility or an out-of-network facility? Again, that's going to affect how much is covered. How many days are covered? The program might be 90 days, but insurance might only cover 30. And if you require medications in recovery, will they be covered by insurance? Because sometimes these are really experimental treatments, and insurance won't cover them. And then additional services. When people go to rehab, going on all-inclusive vacations, some are very basic and some are, the sky's the limit. You get helicopter tours of the volcano. So at rehab, there can be massage therapists, there can be personal trainers. There are all sorts of services rather than a more basic like wilderness program, which where you're not even scrubbing the toilets because there aren't any. So as opposed to the spa. So there are also benchmarks, and you can, in the materials, I've talked about benchmarks in recovery, and those can be recognized by distributions from the trustee. Sometimes recovery is a minimum of 2 years before this switch is flipped and different distributions will be made. For some people, that's a huge amount of time. And for other people who've been addicted for many years and their behavior has been just crazy erratic, 2 years is not enough. And then you have to decide, what if they get through 2 years and then relapse? Do they have to go another 2 years? It really depends on the beneficiary and the issues involved. And this is where your team is going to be very helpful in making the determination how long a period, what kind of distributions, because they will have more familiarity with this particular mental illness or addiction. But ultimately, the beneficiary has to demonstrate a commitment to recovery and state their personal goals and describe how they're going to achieve them for long-term rehabilitation. You have to have some plan in place. Sometimes I see trustees get really excited at the stage of, someone's gone through treatment and recovery and they've been clean for a certain amount of time. And sadly, I had a client who was just so relieved that finally her son hadn't used heroin for 10 days. And this was the longest period he'd gone in years and years and years. She made him trustee of his own trust. And, she's told me several times how much she regrets doing that because the money was gone really instantly. But, even a year out of rehab may not be the right time to make a beneficiary their own trustee. Maybe you make them a co-trustee and you have the ability for the original trustee to remove them if things go south, but don't put the fox in charge of the hen house. One important stage of recovery is relapse, and it's almost inevitable. And so just like addiction, we need to recognize the signs of relapse. And I'm just looking, Bill, how much more time do I have? Oh, okay. So the beneficiary, signs of relapse, the beneficiary can't provide receipts for large purchases. They say they bought a car, but they don't have a receipt for it. And they seem to be spending a lot of money on Ubers. And I've seen that with my own clients. They can't account for their spending. And the story about where the money went is pretty flimsy. There are trends of impulsive spending. There are irregular spending habits. There are increased medical or legal expenses, and again, increased trips to the ER or medical problems. They got injured, they fell, and the facts don't line up. Yeah, the reasons for needing money just don't align with reality. A trust for a beneficiary who may have relapsed but is able to work should cover recovery related expenses. So remember that a beneficiary may still be highly functioning and they may have relapsed and they're working. So the last thing you want to do is give them more money, even though they're working, because now they have extra money to go get in trouble with. So that's something to think about. So again, maintenance, education, support, and health, they may not need that because they've got a job. And so the trustee will need to be aware of whether or not the client who relapsed is now back at stage 1, and you go back and you put into place the distribution standards that you had at stage 1, not at stage 3. So sometimes from day 1, we have the beneficiary who's not going to ever commit to recovery. So what happens then? We've talked about these stages and rewards, and what if they're just never going to get there? If the trustee believes that you can provide in your trust terms that if the trustee believes that the beneficiary is mentally ill or addicted, psychologically dependent, and incapable of caring for themselves, because remember, we have the highly functioning beneficiary, but if they're incapable of taking care of themselves, or they're likely to dissipate their funds if distributions are made, then the trustee can make distributions for basic living requirements, make sure that those needs are met. And again, those distributions should be made for the rent, not to the beneficiary to pay the rent. But it should not be, money shouldn't be distributed that can be used to further their self-damaging behavior. It's really important when you have a provision like this that it is paired with an indemnification provision, because you need to make sure that the trustee is confident that if they carry out these sort of restrictive provisions, that they're not going to get sued. And if you've got the highly functioning, wealthy beneficiary, they've got the resources. And even if they're not going to win the lawsuit, bringing a lawsuit against a trustee is a real hassle. And it's not something that someone's going to take lightly. And, even if they're sued once and the suit is dismissed, it's going to be really hard to convince your trustee to continue to serve after that. So having an indemnification provision that's pretty rock solid is important, just to entice someone to serve as trustee in the beginning. Something that I wanted to mention, there are 2 different services out there that you should be aware of. One is a credit card called, it's called TrueLink, and it's at truelink.com. It's a prepaid bank card, but it limits who can put money into the account. So you can't have some friend go dump a bunch of money in there, which allows you money to get in trouble. And it only pays for what you've authorized it to pay for. So a certain number of gallons of gas, or clothes at a certain store, which would provide clothing for you to go to work, but not at a different store. And it's a great service, but it also results in a lot of calls to the trustee. I went to the gas station and it didn't authorize me to get 16 gallons. It only authorized me to get 15 gallons, or I tried to buy. So you get lots of excuses from beneficiaries sometimes, but it does prevent them from hurting themselves. There's also SoberLink, which is a breathalyzer connected to your phone, and it sends results to members of a team and it can keep you from starting your car. So those are 2 really important resources. So the beneficiary not in recovery, there may be the beneficiary is never going to go to recovery. We've talked about that. But what about the beneficiary who goes to recovery, does fine, and then is no longer in recovery and is never going to go back? That's a different plan. The grantor, again, needs to decide whether or not distribution should be made if that's the case, or they leave the decision in the trustee's discretion. So some of our clients want to control every possible scenario, and some of them want to just rely on their team of trusted advisors. And I pass no judgment on either approach. Some clients are going to want distributions withheld entirely, and others are going to want the trustee to maintain status quo, whatever that is. It could be give them enough money to maintain their addiction. I don't care. I just don't want them to bother me. So they can continue actively using drugs and alcohol. And I'm not aware of whether or not you have here, but we have public housing for people who are actively addicted, and they are allowed to continue to actively use. No, you don't. Yeah, it's a very controversial system, but it recognizes that homeless are often addicted, and so gets them off the street. But I live near one of these facilities, and there is a 911 vehicle out front with lights flashing at all times of day or night. That's the downside, but it's not happening on the street. And some are just going to want the money as a safety net in the event of a catastrophic need. So I've given you a provision in the document, in the materials, that talks about this sort of scenario where we know that the beneficiary is never going to go through recovery. The important part is I request that the trustee limit distributions to such beneficiaries to those that the trustee deems necessary to avoid unusually adverse circumstances that threaten his or her safety, and ensure their basic living requirements are met. So that would be the minimum I would suggest. And then anything over that, you can negotiate. So we've got this trust. Sometimes clients leave a lot of money in trust for a beneficiary who has a really short life expectancy and is not doing very well, and likely the beneficiary isn't going to get a lot of distribution. So what do we do with the money that is withheld? If the trustee is directed to withhold distributions, they need further guidance as to what to do with that money. And again, back to that indemnification clause, they're not going to sit on a whole pile of money unless they're indemnified, because otherwise the disgruntled beneficiary is going to try and use the court to force a distribution, or they're going to retaliate in some other way. The 24-hour-a-day phone calls asking for money until the trustee finally gives in. So the trustee should generally have broad discretion on what to do with the withheld distributions, because the scenarios can all end up differently. But here are some suggestions. The funds might be held for the remainder of the beneficiary's lifetime, because they may still go through recovery and then will want the money there. And there's a very well-known scenario in Seattle. There was a family that funded the arts in Seattle, really gave a boost to the arts, left no money for their kids because their kids were addicts at the time and really didn't think that their kids had a very long life expectancy. They weren't going to need this money. Bill, you probably remember the Krelsheimer Foundation. It's very, very well known in Seattle. Their daughter recovered. She's wonderful. She's involved in the arts, but she's not involved in the arts that her parents supported because she got no money. So all this money went to a foundation that's run by this other guy who enjoys all of the benefits of going to all of these events and being honored for giving this money to the public. And the daughter isn't invited, isn't included, isn't recognized as part of this family. So we don't want that. The funds could be distributed to the remainder beneficiaries. And there may be enough money that you can hold back some and distribute some. It really depends. It could go to a larger group of beneficiaries. The trust could allow for distributions to charity if the beneficiary isn't getting this money. It might be used to support a spouse and children of the beneficiary or a broader group of family members. Or it could just be limited to those that the beneficiary has a duty to support. You could provide that the trustee make those payments directly or to the persons or organizations providing like housing, utilities, healthcare, health insurance, basic goods and services, and to that class of beneficiaries rather than distributing the money to them. So the linchpin of this plan is authorizing ongoing testing and receipt of testing results. And this is the sticky wicket, HIPAA. If a client isn't willing to sign a release so that the trustee and the care team can obtain medical information or opinions from the testing agency or the psychologist, psychiatrist, any of the other professionals involved, then nobody knows what distributions need to be made. They don't know what, they may not know, especially with the highly functioning beneficiary. If the highly functioning beneficiary doesn't allow information to be distributed, then you may not know that they have a problem. And the other thing is when you're drafting about testing, keep in mind that testing evolves. Like who 5 years ago would have thought that you could use your phone as an app to find out if someone was impaired? So HIPAA is tricky, and make sure that you understand it because your team of professionals may not understand it. And I'll just tell you a story as a warning. And if HIPAA is violated, then you risk the loss of confidence of the beneficiary in the team, and that's where things go south. So mom and dad, the kid will not sign a waiver, or the beneficiary. I mean, they could be an adult beneficiary, an adult child. The adult child will not sign a waiver to allow disclosure of information. Okay, that's fine. Mom and dad have all these other professionals. They'll pay the professionals and make distributions to the kid or allow distributions to the kid or pay for their needs if the kid will allow disclosure to the other team of professionals. Okay, so they allow disclosure to, I didn't mention that you can use professionals who will help you find a treatment program. They're usually named Amy. I don't know why. So you've hired Amy and you've asked her to find you a rehab. And Amy knows all the rehabs in Washington, Oregon, California, Idaho, and she knows who to call. She's got them in her Rolodex. And so she can call and find out. She knows which program is the right program, and then find out which one has an opening. Because if they don't have an opening for 30 or 60 days, that's not going to help you. So you pay Amy like $10,000 and she's on the payroll for a year. So she will find you a program. And if that program doesn't work or you graduate out of that program, she'll help you find another program. She'll help you find outplacement, residential treatment. She will be a part of the family for a year. But here's what happens. The kid signs a waiver with Amy. Amy calls the treatment center and says, this is what's going on. Do you have a space? And Bob or Dan says, yes, we do. And so Amy says, all right, I'm going to put the beneficiary in touch with you, Bob or Dan. And I'll put you in touch with the parents because the parents want to find out about this place too, since they're going to be paying for it. Great. So mom and dad call Bob or Dan, and Bob says, well, after 7 days of detox, this is what we do. And mom and dad go, detox? Our kid's bipolar. So that waiver was now, violated by Bob or Dan because Amy relayed that crucial information. So everybody in the chain needs to understand, or now the kid, mom and dad know that the kid needs to go to detox, and the kid gets really pissed at Amy, and now the whole plan has gone south. So HIPAA, really important. Make sure that everybody in the chain of possession of information understands what their duty is to the beneficiary. Let me talk a little bit about gambling and other non-substance use, because that's a whole different problem, and it can be combined with using substances and mental illness. When you have that problem, the trustee needs to be permitted to request the beneficiary to submit to an examination by a qualified healthcare professional. So it's not just going to a drug testing place and having your blood drawn or breathe into a breathalyzer, but they have to be evaluated by somebody who knows how to do that. And that would be a healthcare provider who has some sort of license or certification, a medical doctor, psychiatrist, psychologist, and all of these people would be bound by HIPAA. And there are new kinds of professions that are coming online all the time. So it's important to be aware of that. Just like Amy, I wouldn't have known about Amy 5 years ago, but now Amy's a family member for a lot of people. And you need to draft in order to be, in order to allow the trustee to engage these people who kind of have a mushy description, since it's not a test. You have to talk and they might make a mistake. One thing to think about when you do ask a beneficiary to consent to releasing information, if they're in a 12-step program, including their sponsor in that release is really problematic, because the sponsor is in their court, and you don't want to put the sponsor in a difficult position where they're gonna, tell on the beneficiary. So usually sponsors are not willing to participate in that, and don't ask. Selecting the trustee. If ever there were a time for a professional trustee, this is the place. And it's even better if the trustee has their own professional credentials in addiction and mental health, or they have a team of professionals around them, because this is not for Uncle Bob, especially if Uncle Bob has a good relationship with the beneficiary. This beneficiary may have burned bridges with everybody in the family except for Uncle Bob, and mom and dad might think, well, Uncle Bob has a great relationship, let's put him in charge of the money. The problem is, the beneficiary is never going to be happy with Uncle Bob. And so the beneficiary is going to burn that bridge, and then they're going to have nobody. So preserve that relationship with Uncle Bob. This is a time to have the professional trustee. And I think, we all know that the professional trustee is the right person to use, but our clients sometimes don't want to spend the money to do that. This is the place. And this is also the place to have a trust protector. And if you want, if mom and dad really insist, this is the place where Uncle Bob could be a trust protector, but he's not making the critical decisions that the trustee is making, and he's not getting phone calls 24 hours a day. He's not the bad guy. But the trust protector, you can give any kind of broad or narrow duties or powers. They can even determine that the trust should be terminated. They can actively monitor the beneficiary's recovery, and they can talk to the trustee about proposed distributions or hiring and firing of treatment professionals. So they can do a lot. And sometimes even a trust protector, it's too much for one person. And that's when a trust committee is a great idea. I realize that now we've got a lot of people involved. We've got all these professionals, we've got the trustee, and we've got the trust committee. But if there's money, this is the place where you throw the money at the problem, because it can really make a lot of difference. And, you know, that's what it's for. Special needs, I've written a little bit in the materials about special needs trust, and just make sure that you've got a toggle provision. I mean, if you really do need it to be a special needs trust, that you've got a toggle provision that allows the trustee to turn off the special needs part of it so that money can be used for things that would otherwise disqualify the beneficiary. And then indemnification, really important, and a savings clause. If you've got a trust, you need a savings clause that says, regardless of anything else in this, you know, distributions can be made or withheld that would otherwise blow the S election, the ESBT election, the marital deduction, and even Section 6166 election. You don't want to blow any of those elections. 6166 might not come up, but just keep it in the back of your mind. And then finally, some things that you might want to add to your intake organizer that you give clients, if that's something you do. One question would be, are there any health, lifestyle, or circumstances affecting you or any of those you contemplate naming as beneficiaries or fiduciaries under your plan? So pretty broad. The other question is, might any fiduciaries or beneficiaries have addiction issues, alcohol, drug, gambling, sex, shopping, or other, that could be addressed in your plan? So estate planners need to be aware of the prevalence and numerous manifestations of addiction to be able to address the issues that it creates in a family's estate planning documents and just in their relationships. We're often, as I said, the first people who may be able to recognize that there's a problem, and a well-drafted trust can go a long way towards helping a family of an addicted beneficiary through the stages of recovery, relapse, or choosing not to seek treatment. We cannot solve the problem ourselves. We can help our clients assemble a team, and we can draft the documents, and a well-drafted document can go a long way. So with that, are there questions? Yeah.
You mentioned the trust protector, and I see in your document you've got an explanation of that. Could you give us just a quick 40,000-foot overview on trust protectors? Is Copley a family member? What powers do they have, and how is it used?
Sky's the limit on the powers. And the big issue with the trust protector is, are they going to serve in a fiduciary capacity or a non-fiduciary capacity? If they're serving in a non-fiduciary capacity, then they're not held to the standard of a trustee. They're just a guy out there giving advice. If they're not held to the fiduciary standard, they're less likely to get sued. On the other hand, it's almost impossible to buy insurance to protect them if they are. So there are some people, some practitioners who say they would never serve in a non-fiduciary capacity, and there are others that say you should never serve in a fiduciary capacity. The good news is when you're serving in a fiduciary capacity, there's insurance, so you can be covered. The trust protector could be a family member. It could be another professional. It's really just an oversight committee. Some people don't feel comfortable having one person with too much power. And so they want somebody else who maybe gets duplicate statements, duplicate reports from the professionals. They can hire and fire money managers. They can have as narrow or as broad powers as you want that are within public policy. What else? Any other questions? Yeah. Oh, man. Thank you for asking that question. It's really important when you're drafting your documents that you don't refer to illegal drugs or that you refer to legal and illegal drugs, because cannabis is legal. And so, yes, where does it fit in? I think that's where we fall back on the definition of addiction as self-harm. Because if it's not harmful, then it's no different than smoking, and we're not necessarily going to withhold money for smoking. Does that help? Yeah. What else? Anything from the cyberspace? Okay. 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 Well, if you don't have any questions now, my contact information is in the materials, and really do feel free to contact me. Email is best. Thanks.
Wendy, thanks so very much. I've of course seen a previous presentation on this subject, and of course, very complicated. We're all exposed to it, and of course, none of us have all the answers. So you've got to build your team to pull together to really, kind of try to find solutions. And unfortunately, some people, there are no solutions, and it's a sad situation, but at least we're trying to do as much as we can to head off problems at the past. So thank you for coming. We'll see you July 5th, I think it is, always the first Tuesday of the month. Pete Tentler is going to be speaking about reverse mortgages. He's one of 150 experts in the country, and Paul Hines of Aspirient is going to be throwing in some additional information relative to planning for retirement and having enough funds to take care of your needs as you go through the end of your life. So thank you for coming, and we'll see you in July.